Well, good afternoon and welcome to this, our 8th episode of the 3rd series of 39 from 39, the legal webinar which aims to pack a punch and provide you with your fix of essential developments in the law in 39 fast and furious minutes. This particular webinar, as you will well know because you've registered and joined us today, and it is a delight to see how many of you have done so, is on the UK-EU Trade Cooperation Agreement, and in particular, the following aspects of that agreement. Nuclear, to be presented by Stephen Tromans, QC, Renewables from Ruth, Keating, Agriculture, Gethin Thomas, and Fisheries from Tom van de Klugt. Bios of all of us are available on our website, as are previous 39 from 39 webinars and much besides. Those joining us today may be particularly interested in episodes 2 and 4 of series 3, which also deals, excuse me, with the UK-EU Trade and Cooperation Agreement, but focuses on other topics within it, namely the environment, energy, aviation, chemicals and waste. Today's webinar will be likewise recorded and made available to access on our website in the coming days. As ever, we very much encourage questions either during or after the presentation, and these can be posed using the Q&A function on the Zoom screens in front of you. Now, I'm keen not to eat into our precious 39 minutes. We have quite a lot to get through. So without further ado, I'll hand over now to our speakers, starting with Stephen. Thank you.
Thank you, Richard. It's good to be with you all, albeit remotely this afternoon. If we could move on the slides, please. Great. So I'm going to cover the nuclear cooperation part of the Trade and Cooperation Agreement. And when we decided in the referendum to leave the EU, that engendered some legal debate over whether that also meant we left Euratom, the European Atomic Energy community. And some people said, well, giving a notice to leave the EU doesn't necessarily mean you leave Euratom as well. But it was inevitable, really, that we would get into Brexatom as well as Brexit, having been members for over 40 years, because quite simply, there would have been too many red lines of freedom of movement, immigration, jurisdiction of the European Court of Justice, and also state aid issues, which were quite problematic, although resolved in relation to Hinkley Point C. So I think it was inevitable politically that we would go. But that did raise a number of quite challenging and controversial issues. I think it's fair to say that nobody had given much thought within the government to what the implications of leaving Euratom would be. The UKLA Brexit Working Group published a very fast report highlighting some of those. I co-authored that with Paul Bowden of Freshfields. And as we'll see, we now have the Trade and Cooperation Agreement, which is accompanied by a separate agreement, the EU and UK Agreement for Cooperation on Safe and Peaceful Uses of Nuclear Energy. So that is what I will be focusing on predominantly. Next slide, please. So a few words on Euratom. It was established in 1957, shortly after the Common Market, as it was then known. Its goals were ensuring access to nuclear material and the free movement of capital and experts, people within the community. It set up a supply agency to ensure equitable access to nuclear fuel and other nuclear materials. And Euratom itself became a party to various conventions and to, importantly, nuclear cooperation agreements with third parties such as the US, Australia and Canada, who were very important in terms of nuclear technology and also the provision of uranium as nuclear fuel. It also has an important role in ensuring the supply of medical isotopes, on research, notably in recent years into nuclear fusion, on safeguards inspections, and has become over the years increasingly interested in nuclear safety and safe waste management and management of spent fuel. So next slide, please. The challenges of withdrawal, some of these seemed quite alarming at the time. It all looked like a recipe for some real problems. First of all, ensuring fuel supplies, the import of uranium hexafluoride for enrichment and fabrication into nuclear fuel coming from outside of the UK. 80% of medical isotopes used for diagnosis and treatment of cancers, etc., come from the EU. There was a very large framework of Euratom safeguards which would cease. It would be necessary to ensure the continuity of third-party cooperation agreements, because otherwise the US would not be able to transfer technology and information to us in relation to nuclear programs. How are we going to secure continued participation in research, particularly on fusion? And Euratom, the European Supply Agency, had ownership of fissile special material in the UK, and that would cease with withdrawal from Euratom. So there were many challenges really that had to be thought through and explored. Next slide, please. Safeguards is one of them. So we had to replace the agreement between Euratom, the International Atomic Energy Authority, and the UK by an agreement leaving Euratom out directly between the UK and the IAEA. We had to bring in our own domestic safeguard system to be addressed by the Office for Nuclear Regulation. We had to pass some primary legislation, the Nuclear Safeguards Act, to do that, and also secondary legislation under it. And we had to conclude bilateral cooperation agreements, which we did with the US, Canada, Australia, and Japan. Now, the inspection of UK facilities for safeguards did involve a very large resource provided by Euratom. Around 26% of Euratom's inspection resource was in the UK, and the scale of that was shown by the fact that loans effectively, or advances of around 7 million, had to be made on an emergency basis from the UK Contingencies Fund to BEIS, Department for Business, Energy and Industrial Strategy, to set up that domestic system. Next slide. Cooperation agreements. The cooperation agreement between us and Euratom. Essentially, we started from the basis that we were at comparable levels of regulation, nuclear safety, safeguards, and security. So there was no great disparity. Also, helpfully, that both parties would benefit from cooperation in peaceful uses of nuclear energy, and that both subscribe to international standards on nuclear safety and related matters from the IAEA to the Treaty on Non-Proliferation and the Convention on Physical Protection of Nuclear Material. So there's a great deal of common ground, helpfully. And also the importance of further research was mutually recognised into advanced technologies and in collaboration. All of this is confined to peaceful purposes. This is not to do with nuclear weaponry. It's cooperation for the purposes of things like power generation, medicine, industry, and agriculture. Next slide. Article 1 deals with the scope of cooperation. So I won't read out that list, but as you can see, it's a pretty comprehensive list of the areas in which there will be cooperation. A number of them I've mentioned already. Next slide. And Article 4 of the agreement deals with the forms of cooperation. So that can include things like the transfer of technology and materials, exchanging information, facilitating cooperation through exchanges and training, symposia and seminars, exchange of information, joint projects and ventures, commercial cooperation on nuclear fuel services, and a rather sweeping up category, any other forms of cooperation which may fall to be determined in due course. So next slide. Safeguards, security and safety. These are the three fundamental matters of nuclear regulation, essentially. So Article 6 requires that nuclear material must be subject to the appropriate safeguards regime, both within the European community and within the UK. both parties undertake to implement robust and effective systems of nuclear material accountancy and control. That's what we had to set up to be administered by the ONR. On the question of physical protection and security of nuclear material and its safe transport, Article 7 requires the application of IAEA standards, so they should provide common standards between us. And Article 8 records the adherence of both parties to the relevant conventions on nuclear safety, assistance and notification in the case of accidents, and working together to achieve continuous improvement on nuclear safety standards. The recorded commitment is not to weaken protection, and it's also recorded that the UK may participate as a third country in various Euratom groups. We'll come on to that further in a moment. Next slide. On trade, Article 9 contains a mutual agreement to facilitate trade and procurement of relevant items and materials and technology, provided that these are in accordance with relevant international commitments and proper safeguards and are under fair commercial conditions, and so as not to frustrate the common supply policy of the community. There are provisions restricting onward transfers and retransfers of materials, so material which is transferred to the UK under these provisions cannot necessarily be transferred on to other parties. There would need to be consent of the supplier party and also compliance with the rules of the nuclear suppliers group, intended to avoid things like centrifuges and other equipment being used for nuclear weapon purposes. There is a framework provided on the import and export of trigger list and dual use items. So again, those are technologies which may be used for non-peaceful purposes. Potentially, they have to be very carefully controlled. The substance of the law remains the same, but there is a new system for UK export licenses, which is in place and is required instead of the EU or Euratom system. Next slide. There are some provisions that deal with enrichment, with reprocessing of fuel and with research. So Article 10 says that the consent of each party is required prior to the enrichment of uranium. Consent is given automatically to the reprocessing of nuclear fuel, subject to compliance with some conditions set out in an annex to the agreement, essentially there to ensure the peaceful use of plutonium arising from reprocessing. There is agreement on mutual cooperation on research and development for peaceful uses, power to allow cooperation between bodies like universities, laboratories and the private sector, and participation by the UK as a third country in community programmes, and in particular membership of the Euratom Fusion for Energy programme. There is a joint declaration made pursuant to the agreement which allows participation by the UK in Euratom programmes. So, for instance, the experimental reactor, the thermonuclear fusion reactor down at Cadarache near Aix-en-Provence in France, and the more wide Fusion for Energy programme. And an agreement was entered into in 2019 to provide 100 million euros of continued European inward funding for the joint European Taurus project, again, nuclear fusion at Culham in Oxfordshire, run by the UK Atomic Energy Authority. It's also important to note Annex 3 of a decision 2020, which deals with security procedures for exchanging information, and also application to the UK of an agreement between Euratom and Japan, again for collaboration on fusion. Next slide, please. Article 13 of the agreement provides for promotion of appropriate and proportionate exchange of information and technical expertise. The agreement doesn't transfer any intellectual property. That will have to be dealt with separately, but any material which is transferred must be adequately protected by the receiving party. And Article 16 provides the agreement shouldn't be used for the purpose of seeking any commercial or industrial advantages or for interfering with nuclear policy of either party or of member states. So, for instance, if there was pressure within Euratom to prejudice the UK because it favours nuclear energy, whereas many members of Euratom now don't, that it wouldn't be valid to use the agreement for that purpose. Next slide, please. There is a procedure for a joint committee to deal with disputes, amongst other things. The joint committee deals with the exchange of information. It can establish working groups. It can consult on technical issues. It can adopt recommendations, and it can coordinate action if it's necessary, in particular to minimise the risks of shortages of medical isotopes. The disputes are discussed initially by that joint committee. If they're not resolved, they're to be submitted to a 3-person arbitral tribunal. There is a default provision whereby the agreement can be suspended or terminated in the event of serious breaches, by which I mean, for instance, unauthorised enrichment or failure to physically protect nuclear material or to administer a proper safeguards regime. Next slide, please. So the overall assessment, I think it's fair to say that little should change in terms of safety, security and safeguards, except of course it won't be Euratom which does the inspections now. The necessary continuity has been secured on the international agreements with other parties, which are essential for us to have a supply of uranium and necessary technology. There is a process that's been developed for the movement of radioactive sources under the shipments regulations of 2019. We hope in the UK to reduce our reliance on the import of radioisotopes for medical purposes by a new medical radioisotope and a research reactor that is being developed. And we will continue to participate in the fusion research and other Euratom initiatives. And we have, as part of our own programme now, announced proposals for our own fusion reactor, very firmly with the Union Jack on the side of it, to be developed by the UK AEA. And it's possible we may move towards, although I think that hasn't been achieved yet, I think it's a work in progress, associate status under Article 206 of the Euratom Treaty. So, next slide, please. Final pictorial assessment. This is by reference to my recent haircut this weekend or last weekend. Both photos are me, extraordinarily. The first one is sort of how things looked in 2017, a bit unpromising and a bit messy. The second photo is how they look now, which is much tidier and much more in control. So I think we're in pretty good shape, is my assessment in relation to the nuclear field following leaving Euratom. That is it. I will move on or hand on to the next speaker, which I believe is Ruth.
Thanks, Stephen, for that, and thanks for sharing the haircut pictures, which I think we can all relate to after months of having no haircuts ourselves. Hi, everyone. I'll be covering the impact on renewables under the TCA. Now, of course, the TCA itself is naturally a long document, but looking at the document on the whole, only 15 pages and 33 articles relate to energy. So as we go through and look at those provisions relating to renewables, the headline point is that there is still much agreement that has to be reached, but much of the agreement between the EU and the UK has, unsurprisingly, been achieved at this point, with the details yet to be ironed out. So if we look what we have there on our screens, we have the overall obligation, which is evident in respect of renewables. For those who want a summary of how the TCA relates to renewables, Part 1 explains the institutional framework, and importantly, this includes a partnership council which will oversee the implementation of the agreement. But for energy purposes, it's worth noting that its supporting committee structure includes a specialised energy committee, as well as other trade-focused committees. And so that's certainly something which we'll look to in the future to see how those rules and practices develop out as the years go on. Finally, and in terms of energy and renewables, the most important part of the TCA is Title 8, and that states the objectives being to facilitate trade and investment between the parties, but particularly it states in areas of energy and raw materials, and to support security of supply and environmental sustainability. And so that is very much at the heart of the provisions we see for renewables. The difficulty, of course, being that all of this happens against the backdrop of trade and investment. And some of those provisions might not go as far as we would have hoped in terms of encouraging and supporting renewables. But if we look at the next slide, we'll see one of the most important sections, and that's Article 6 ENER. And really the main provisions we see are under Article 6, 8, 21 and 22 in particular. If we look at Article 6, it's really one of the headline points, but the focus here is that markets should enable the integration of renewable energy sources. And I think what's notable when we look at Article 6 is that we see some very high level requirements in respect of wholesale and electricity gas markets. But particularly if we look at subsection 6, after we see provisions on restricting trade and enabling efficiency, we see that the TCA has explicitly provided for enabling the integration of electricity from renewable energy sources and ensuring the efficiency and secure operation and development of the electricity system. And more importantly, even for Article 6, if we look at subsection 2, we see that each party is to ensure the balancing of markets are organised in such a way as to ensure that producers of renewable energy are accorded reasonable and non-discriminatory terms. And really, we go on to have further detail in the TCA, but Article 6 really sets the tone. The aim of the TCA in respect of renewables is to make sure there's no distortion of trade between the parties, not necessarily always to advance renewables above other forms of energy. But if we look at Article 8, which is on the next slide, and in particular, Article 8 deals with transmission and distribution networks, and of course, a hugely important aspect of the TCA in respect of renewables and certainly the development of renewables. So if we look at subsection 2 there, what that says is without prejudice to Article 4, which lays out the principles. And to remind ourselves of what Article 4 says, that simply provides that each party has the right to adopt, maintain and enforce measures necessary to pursue legitimate public policy objectives. So the more specific provisions we see there very much tied to that broader backdrop. But we do importantly see under Article 8 that without prejudice to Article 4, each party is to ensure that the transmission system operators treat producers of renewable energy on reasonable and non-discriminatory terms regarding connection to and use of electricity networks. And so I think what we see as a very important part of the TCA in respect of renewables is that both the UK and the EU in their previous relationship as the UK as a member state have achieved a significant amount of progress in respect of renewables. But what's hugely important is that new entries into the market are not dissuaded from doing so. And so really that's what Article 8 is focused at when we look at the language there. After Article 6 and Article 8, we move into some of the more meaty provisions in respect of renewables. And that's on the next slide when we see Article 21 ENER. And we see some of the headline provisions there. Now, in respect of renewables, this is one of the most important articles. It specifically deals with renewable energy and energy efficiency. And it also provides, in slightly stronger language than we've seen in other parts of the TCA, that each party shall promote energy efficiency and the use of energy from renewable sources. It's a slightly more encouraging use of language than other articles. However, clearly it's not a strict or clearly defined standard. And so that is something which both parties will have to look at over the coming years to see whether either party is trying to reduce that or simply not promoting renewables in the way that the TCA appears to be requiring here in terms of the language used. But importantly for Article 21, it also continues that each party shall ensure that its rules that apply to licensing or equivalent measures applicable to energy from renewable sources are necessary and proportionate. And so again, we see the language tying back to what we saw in Article 6 and Article 8, very much focused here on the prevention of distortion of trade. If we can move on to the next slide, we see some of the more aspirational language here. And what's really been maintained here is the status quo between the UK and the EU. In particular, what is defined there is that the Union reaffirms its targets for the share of gross final energy consumption from renewable energy sources in 2030. Similarly, we see the EU reaffirming its relevant energy efficiency targets, which are listed there on your screens. And finally, we see a similar obligation placed on the UK, albeit in slightly different language, unsurprisingly. What is being achieved there is that the UK is reaffirming its ambition for the share of energy from renewable sources in gross final energy consumption in 2030. And that state is being as set out in the National Energy and Climate Plan. And finally, we see again the ambition for the absolute level of primary and final energy consumption in 2030 as set out in the National Energy and Climate Plan. And the most important point there, finally, in terms of the developing relationship between the UK and the EU, is that parties shall keep each other informed in relation to the other matters we see in Article 21. So certainly when we analyse the provisions there are some strong obligations in respect of renewables. We don't see the TCA going as far as providing for more favourable parameters for renewables. That is very much something which is left to union policy, and on the flip side, something which is very much left to UK domestic policy as well. But thankfully, we do see here the clarification that existing obligations do continue to exist, and of course they're enshrined there now in the language of the TCA. Finally, if we move to the next slide, we see Article 22, it goes slightly further. Again, this is titled Support for Renewable Energy, so we're building on something more onerous in terms of obligations here. And what that says in subsection 1 is that each party shall ensure that support for electricity from renewable sources facilitates the integration. So that's something slightly higher there. And in terms of subsection 2, we see biofuels, bioliquids and biomass only being supported as renewable energy if they meet robust criteria for sustainability and greenhouse gas emission saving, which are subject to verification. And so importantly, again, we see these provisions of renewables very much being tied against the backdrop of trade at the heart of the TCA, and ensuring that no party seeks an advantage by lowering the standards in respect of renewables, which could have some obvious economic advantages, but clear disadvantages also. And finally, we see there that each party shall clearly define any technical specifications which are to be met, and such technical specifications shall take into account the cooperation under other articles which are referenced there. So certainly when we look at the provisions here in terms of Article 22, we see more teeth in terms of what can be achieved between the EU and the UK in terms of monitoring each other's trade relationship and stopping either party relying on older sources of energy at the expense of renewables. If we turn to the next slide, we see the final highly relevant article in terms of renewables. And again, this deals with the cooperation in the development of offshore renewable energy. Now, as an overall point there, we see again the obligation of sharing best practices and, where appropriate, facilitating the development of specific projects. Certainly the language there is more aspirational than something which would have any teeth between the parties. But certainly when we move on to look at subsection 2, it says, building on the North Sea's energy cooperation, the parties shall enable the creation of a specific forum for technical discussions. And that says, particularly in relation to offshore grid development and the large renewable energy potential of the North Seas region. And there are specific areas there listed on your screens. Now, naturally, looking at Article 23, this is one of the areas where continued cooperation is probably most vital if the considerable potential of offshore wind farms in particular are going to be maximised. And for example, projects that combine large-scale wind farms with physical interconnection of different countries. And sadly, the effect of Brexit has been that the UK is no longer a member of the North Seas Energy Cooperation. And so Article 23 is very clearly aimed at promoting the development of offshore grids and renewable energy, even in the absence of the UK being a member. And so looking at that language there, really the issue is that there is going to be some cooperation between the parties, but in terms of the development that we see of electricity infrastructure in the North and Celtic Seas, there's going to inevitably be susceptible to some changing relationships and political priorities in a way that we didn't have previously. If we can just move then to the next slide, and this is cooperation on renewables. We have on your screens there Article 25 and 26. These are of course big parts of the cooperation between the parties, and it says the parties shall promote cooperation between the regulators and standardisation bodies in their respective territories. And of course, it encourages research and development. If we can move on to the next slide in relation to RIGO, and what I flagged there briefly on your screens, it's important to keep in mind that I'm sure we all remember that the hourglass moving down in terms of time, and the worry in December that the deal wouldn't be reached. Now, of course, one of the big challenges for that has been mutual recognition. And you see on your screens there, one of the areas which hasn't been agreed, that's renewable energy guarantees of origin as proof of an energy supplier's fuel mix. No agreement on that has been reached, and it's important to keep in mind that as a result, what that means is that in the UK, those RIGOs are no longer recognised in the EU, and vice versa, the UK will continue to recognise RIGOs of EU origin, but this is something that the government has said it's going to review in 2021. And if we move to the next slide, and my final slide, and unfortunately we don't see a photograph there like Stephen's haircut, but we do see a point there looking to the future. And in terms of the agreement that has been reached, the previous slide that you've seen underlines the importance of agreement being reached between the parties on certain matters, but not all matters. And certainly this being an area which will continue to develop between the parties. In terms of dates for your diaries, the energy aspects of the TCA will terminate on the 30th of June 2026. And although that may be extended by the Partnership Council until 2028, the latest, there are many details which still need to be ironed out. And so certainly this is going to be something of an area to keep watching in terms of those continuing energy negotiations between the UK and the EU. And with that, I'll pass on to Gethin. Thank you.
Thank you very much, Ruth. So I'm going to be addressing agriculture. By way of context, the UK and the EU share a mutually important agri-food trading relationship. The UK is a net importer of agricultural products. In 2019, a significant share of the UK agri-food imports came from the EU, some 74%. And EU countries export large volumes of agri-food products to the UK, notably fresh and processed fruit and vegetables and meat products. And in 2019, the value of those exports was approximately 41 billion euros. Similarly, the UK's exports to other EU member states accounted in recent years for some 60 to 65% of its total agricultural exports. Major EU export markets of the UK's agri-food sector are Ireland, France, the Netherlands, and Germany. Now, those imports and exports have historically taken place pursuant to the EU Common Agricultural Policy, which was created in 1962 by the 6 founding countries of the EU and is the longest serving EU policy. Please can I have the next slide? And the UK has been a part of the Common Agricultural Policy since 1973. And it has 3 main strands. The first is the provision of income support through direct payments to farmers and others, which ensure income stability and remunerates farmers for environmentally friendly farming and delivering public goods that would not necessarily be paid for by the markets, such as taking care of the countryside. Secondly, it provides for market measures to deal with acute, difficult market situations, such as a sudden drop in demand, like VCJD, or a fall in prices as a result of a temporary oversupply in the market. And thirdly, it also makes provision for specific rural development measures with national and regional programmes. The CAP income support in the EU is provided by 2 funds, which form part of the EU's general budget, the European Agricultural Guarantee Fund and the European Agricultural Fund for Rural Development. Before Brexit, farmers in the UK received around £3.5 billion of support annually under the EU's Common Agricultural Policy. And many UK farms would not have made a profit without CAP support. DEFRA estimated in 2018 that without those direct payments, some 42% of farms would have had costs exceeding their revenue. Before turning to the TCA provisions themselves, it's important to first address the Agriculture Act 2020, which came into force at the end of last year, ahead of the Christmas Eve agreement of the TCA. The Agriculture Act 2020 provides the legislative framework for new agricultural support schemes after Brexit and the UK's departure from the Common Agricultural Policy. Please can I have the next slide? And this is perhaps the most insignificant part of the Act in terms of its implications for farmers and the environment. Part 1 of the Act includes a range of provisions to allow the Secretary of State to establish a new agricultural system based on the principle of public money for public goods after the UK leaves the EU. The main clauses provide enabling powers for ministers to pay farmers and to phase out the current system of direct payments. This means a shift from the majority of farm support funds paying farmers for how much land they farm to paying public money for public goods such as environmental improvements. Notably, the Act also provides that in the event of exceptional market conditions, which the Act defines as where there is some severe disturbance or a serious threat of disturbance which will have a significant adverse effect on agricultural producers in terms of the prices achievable for agricultural products, such as the outbreak of foot and mouth, for example, the Secretary of State may intervene in agricultural markets. In terms of the Secretary of State's power to give financial assistance, I've set that out on the previous slide. Please, Richard, which notably includes a power to give financial assistance for starting or improving the productivity of an agricultural, horticultural or forestry activity, or supporting ancillary activities carried on or to be carried on by or for produce. So it's a very broad array of purposes that are set out there on the slide. This power only applies to England. Come on to talk about the position in relation to the devolved regions. And in framing any financial assistance scheme, the Secretary of State is obliged to have regard to the need to encourage the production of food by producers in England and its production by them in an environmentally sustainable way. This duty to have regard didn't find its way into the first draft of the bill, but came as an amendment during the bill's course through Parliament. Moreover, the Secretary of State must also, in relation to each financial assistance scheme, monitor the impact of the scheme and make one or more reports on its impact and effectiveness, having had regard to the findings of that monitoring. Non-tariff measures. Although tariffs on agricultural products have been avoided, which I think led the agricultural industry breathing a deep sigh of relief, a fundamental change is that the UK is now trading with the EU as a third country. As such, trade is now subject to a series of non-tariff measures under the TCA, which include, for example, additional physical checks, advanced notification of loads, export health certificates, and labelling requirements. Please can I have the next slide? In order to qualify for tariff-free and quota-free trade, a product must meet the rules of origin requirements, which is a criteria used to determine where a product was made. And the TCA permits EU components being used in the manufacture of GB products and vice versa to count towards a product meeting the rules of origin requirements. However, EU components must undergo sufficient processing in the UK. In particular, goods which are imported from the EU, which are due then to be re-exported to the EU, that haven't undergone sufficient processing may be liable to pay tariffs when re-entering the EU. So for example, the GB-based supermarket chain buys Parmesan from Italy, packages it and sells it to a consumer in Ireland. It's not uncommon. That would get caught by the rules of origins requirements and wouldn't count as sufficient processing. By contrast, using Dutch bacon in a ready-to-go sandwich or machine grating the Parmesan before selling it would amount to sufficient processing. And part and parcel of the rules of origin is that importers and exporters must be able to show compliance. And that necessarily involves additional controls and paperwork. The other main area of non-tariff measures in terms of what the TCA makes provision for are sanitary and phytosanitary checks, or SPS. Now, these are border controls which involve the most extensive checks, specialist paperwork, frequent physical inspections on products of animal origin, most notably including, for example, quarantine and other biosecurity measures. The UK and EU post-Brexit will maintain separate regimes regulating human, plant and animal health. The TCA sets a fairly broad brush general aim of keeping SPS checks to a minimum. The agreement places a duty on both sides to ensure that SPS border controls are proportionate to the risks identified, but the TCA does not remove the need for them, nor does it specify a particular limit, a maximum quota of SPS checks. A trade specialised committee on SPS measures is established pursuant to the TCA under Article INST.2d, and Article SPS.19d equips the committee with the power to regularly review the two parties' SPS measures in order to facilitate trade between them. Now, the UK didn't achieve its ambition of agreeing an equivalence mechanism for SPS measures, nor did it manage to agree a reduced level of checks or fees similar to the EU-New Zealand veterinary agreement, under which only 1% of goods are subject to SPS checks. And the House of Lords Subcommittee on the Environment, which recently published a report on the TCA, noted particular criticism for that and stated that they were disappointed that the government and the EU did not achieve more through SPS measures, chapter of the TCA, and that's resulted in substantial barriers to trade which risk reducing the profitability of parts of Great Britain's food and agricultural produce sectors. And the House of Lords Subcommittee urged the government to seek supplementary agreements with the EU, which would be along the lines of the EU-New Zealand agreement. They noted, rather blithely perhaps, that they found it strange that the TCA accomplishes less on SPS measures by comparison to the New Zealand agreement. Next slide, please. There are potentially significant implications for the environment and food standards, animal health and welfare that go beyond the threat of chlorinated chickens, although the 2 chlorinated chickens on the slide at the bottom right-hand corner seem misleadingly content. Under Section 42 of the Agriculture Act 2021, a free trade agreement that includes measures applicable to trade in agricultural products cannot be laid before Parliament unless the Secretary of State has first laid a report which explains whether or to what extent the measures are consistent with the maintenance of UK levels of statutory protection in relation to human, plant or animal health, animal welfare and the environment. Although UK levels of statutory protection are now, post-Brexit, potentially more variable. The Trade and Agriculture Commission is tasked with producing a report on each free trade deal on the Secretary of State's behalf. And there are a number of specific areas with particular scope for change. Section 33 of the Agriculture Act 2020 amends Part 4 of the Agricultural Act 1970 to enable a much broader range of materials to be regulated as a fertiliser in the UK. Section 33(2) of the Act broadens what is defined as a fertiliser to allow for the appropriate regulation of this new innovative market. Section 33(3) allows a regulation of fertilisers on the basis of their function, in addition to regulation based on composition or content, which was the case under the 1970 Act, allowing different requirements to be set for different types. The Delegated Powers Memorandum, which was published alongside the 2020 Act's introduction to the Parliament as a bill, states that it's intended that there will be a staged rollout, which will allow regulators to gain experience running the system with lower risk functionalities and components before increasing the ambition to regulate for higher risk materials. Section 31(4) of the 2020 Act also allows regulations to amend and repeal EU Regulation 2003 relating to fertilisers and other retained direct EU legislation. Notably, the 2020 Act also imposes a duty on the Secretary of State to, at least once every 5 years, prepare and lay before Parliament a report containing analysis of statistical data relating to food security in the UK. And on animal health and welfare standards, much of the UK law implements broader EU policies. The deal commits, in very broad terms, to ongoing UK and EU cooperation on animal welfare, antimicrobial resistance and sustainable food systems. But there is now potential scope, subject to the level playing field provisions of the TCA, for divergence in welfare standards. Finally, very briefly, under the Agricultural Act 2020, ministers now have powers to make new provisions to amend existing provisions regarding organic certification, the import and export of organic products, and the enforcement of organic regulation. The TCA expressly provides for mutual recognition of EU and UK organic regimes. And also very briefly, the EU law currently regulates the release of genetically modified GMOs into the environment and the marketing of GMOs through the GMO Release Directive. Its provisions are currently implemented in England and Wales under the Environmental Protection Act 1990. GMOs are used much more widely in the United States than they are in Europe. Currently, since 1990, only 3 GMOs have been authorised for cultivation in the EU, and only 1 is currently authorised, although it's not used in the UK. But depending on the outcomes of other free trade agreements and what the Trade Commission has to say in its reports, this may well be something that we might see more of in the United Kingdom, something of a watch this space. But crucially, the central achievement of the TCA, tariff and quota-free trade, could be put at risk by future divergence, depending on the degree of divergence. Please could I have the next slide? And this is because the rebalancing mechanism in the TCA could allow a party to introduce tariffs or any other appropriate rebalancing measure if, under Article 9.42, material impacts on trade or investment arise if significant divergences in environment or climate protection, among other areas, were to affect trade or investment between the parties. Accordingly, GB may have to walk something of a tightrope if it wishes to explore significant divergences to avoid losing the key benefits of the TCA for agricultural trade. And finally, on devolution, agriculture is a devolved subject matter, And as such, following Brexit, there will now be divergences in agricultural regulation, as well as in financial assistance across the 4 devolved nations. Please can I have the next slide. All 4 devolved nations have significant farming industries, and there are photos there from Wales, Scotland and Northern Ireland, although I don't have any prizes for correct guesses. In Northern Ireland, my understanding is that post-Brexit policy is still being formulated. In Wales, the Agriculture Wales Bill has recently been subject to public consultation, which closed at the end of last month, and it places a great emphasis on sustainability and seeks to establish a farm support scheme to replace the CAP entitled Sustainable Farming Scheme. The proposed scheme would address climate change, public health and environmental issues associated with agriculture by implementing SLM. And this, it's also intended to introduce proposals to improve animal health and welfare. In Scotland, again, specific policies are still being developed, but the Agriculture Retained EU Law and Data Scotland Act became law on the 1st of October last year, which empowered Scottish ministers to ensure that the CAP can continue beyond Brexit, as well as retaining the ability to make improvements to the scheme following the agreement of the TCA. I will now hand over to Tom.
Good afternoon, everyone, and thank you very much for coming along today. We really do appreciate it. Just to wrap up, I'm going to give something of a whistle-stop tour of the fisheries provisions of the TCA. So firstly, just by way of context, I've put here 2 quotes from the UK government website and Europa websites, respectively, just to give a flavour of how each of the parties has framed this agreement. And you'll see that the UK government statement says the agreement reflects the UK's departure from the EU's common fisheries policy and new identity as a sovereign independent coastal state with the right to manage the resources in its waters. The UK is now free to create its own laws and fisheries management practices to the benefit of fishers and coastal communities across the whole UK. The EU statement, by contrast, says the EU and the UK agreed on a new framework for the joint management of fish stocks in EU and UK waters. The UK will be able to further develop British fishing activities, while the activities and livelihoods of European fishing communities will be safeguarded and natural resources preserved. Now, it's interesting to note the contrasting descriptions of the same agreement, with the UK government framing it as reflecting a departure from the common fisheries policy and enabling freedom for the UK to set its own rules within its waters, while the EU statement describes the agreement as a framework for joint management of fish stocks. Those are 2 very different interpretations. And as with many areas of the agreement, it's very much a case of the meat remaining to be put on the bones. And those differing approaches that the parties take, which of course may evolve in future, I think will be crucial to how the agreement is actually put into practice. We don't have time today to go into the details of the common fisheries policy, but certainly the agreement does of course reflect the UK's departure from it. The key point about it is that under it, the exclusive economic zone, so the part of the waters extending 200 nautical miles out to sea from the shores of the coastal states, was managed as a single EEZ for the EU. That included the UK's EEZ. Now, of course, the UK's EEZ falls outside that EU EEZ as shown by this map. So that is a radical change. And what the Common Fisheries Policy did, of course, was enable all member states to have access to those waters and to set in annual rounds of negotiations quota levels for fishing from those waters. It's also worth noting that the roots of the Common Fisheries Policy, as with the Common Agricultural Policy, were increasing productivity, stabilising markets, providing a source of healthy food and ensuring reasonable prices for consumers. Now, those aims evolved, but certainly that history of the policy being designed to mainly cater to production and consumption is something that dictated the way that it was framed. So how then is the Trade and Cooperation Agreement structured? Well, part 2 of the TCA deals with trade, transport, fisheries and other arrangements. And heading 5 contains the specific provisions on fisheries. These are split down into 4 chapters. Firstly, initial provisions, which contains overarching objectives and principles, as well as some definitions applying to that heading. Secondly, conservation and sustainable exploitation provisions. Thirdly, arrangements on access to waters and resources. And finally, some arrangements as to governance. The provisions under heading 5 are accompanied by annexes Fish 1 to Fish 4, which contain further details in relation to fish stocks, in relation to the access arrangements and the protocol for access to waters. So going into those areas in a little more detail, it's the access and quota arrangements which have attracted the most press and public attention. And of course, they were previously always a controversial and politicised issue when the UK was under the remit of the CFP. But what has attracted less attention, perhaps, in terms of the TCA is these objectives and principles that are overarching. They're set out in Chapter 1. And Article Fish 2 sets out 2 objectives. The first is that the parties shall cooperate with a view to ensuring that fishing activities for shared stocks in their waters are environmentally sustainable in the long term and contribute to economic and social benefits, while respecting the rights and obligations of independent coastal states. We can see there again this tension or balancing act, if you like, between these different conceptions of the agreement as a joint management tool on the one hand, and as something that enables for the UK the ability, supposedly at least, to assert its rights as an independent coastal state. The second objective that is set out is that the parties share the objective of exploiting shared stocks at rates intended to maintain and progressively restore populations of habited species above biomass levels that can produce the maximum sustainable yield. Now, that concept, maximum sustainable yield, is one that features in the Common Fisheries Policy. It's one that has attracted, again, much controversy in terms of how fishing stocks are managed. And that continues to be a key part of this agreement. So in that sense, there is some continuity with the CFP, and certainly it indicates, and I'll comment on this more later, but it indicates, I think, that the provisions of the TCA are not a game changer in terms of the way that management of fishing resources and impact on the environment is framed conceptually. The agreement then continues in Article Fish 2.3 to provide that the parties shall have regard to 9 principles. Now, I won't read them all out, but just to highlight a couple of important ones, the parties will apply the precautionary approach to fisheries management. This is a recognised, established principle in fisheries management internationally, but it's also defined in the agreement in Article Fish 3 as an approach according to which the absence of adequate scientific information does not justify postponing or failing to take management measures to conserve target species, associated or dependent species, and non-target species in their environment. Another principle that the parties must have regard to is promoting long-term sustainability, environmental, social and economic, and optimal utilisation of shared stocks. Note there the way that sustainability is framed not just as an environmental, but as a social and as an economic matter. And again, the phrase optimum utilisation of shared stocks, which in the way that it conceptualises how fishing stocks should be managed for optimal utilisation, is again sort of in continuity with the Common Fisheries Policy, I would suggest. And then finally, just another principle to highlight at E there, taking due account of minimising harmful impacts of fishing, and at F, applying proportionate and non-discriminatory measures for conservation while preserving the regulatory autonomy of the parties. Now, what I'd note there is that there are terms such as have regard and taking due account, which have a discretionary element to them. And both the parties and relevant authorities within them will need to consider how these obligations should actually be implemented in practice and what the scope of those terms is. And we can also see there, again, I think, this balancing act between the concept of the agreement as a tool for joint management of a shared resource and one that, in theory at least, allows the UK, or both parties, in fact, regulatory autonomy over their waters. And again, the question will be, how does that tension play out in practice? Chapter 2 of Heading 5 contains provisions about conservation and sustainable exploitation. And Article 4 says that each party shall decide on any measures applicable to its waters in pursuit of the objectives set out in Article 2.1 and 2, which we've just covered, and having regard to the principles referred to in Article 2.3. So the way that conservation and sustainable exploitation provisions are framed in the agreement is to refer back to those objectives and principles. The provision goes on to say that the party must base these measures on the best available scientific evidence, and also that the parties shall not apply measures referred to in paragraph 1 to the vessels of the other party in its waters unless it also applies the same measures to its own vessels. So there is a level playing field provision. The final part of the provision, Article 4.3, provides for a notification mechanism whereby each party is required to notify the other party of new measures that are likely to affect the vessels of the other party, allowing sufficient time for the party to provide comments or seek clarification. Now note here the broad wording, which I think will leave much up to the day-to-day implementation of this agreement by relevant authorities and the nature of the cooperation between them. In particular, the wording around sufficient time and provisions of comment and seeking clarification, that's quite flexible. And to function effectively, it would appear certainly that a high level of mutual understanding and coordination is going to be required. We also saw the reference to best available scientific evidence. Now, of course, in this highly technical area where information about fish stocks has long been a controversial topic, that concept, I think, could potentially be one, again, where parties and authorities will need to consider scope and where contention could possibly arise. And finally, of course, there's the question of what the measures will actually be that the parties implement to further the objectives and have regard to the principles. That is left completely open-ended. So we'll see. The second provision in the conservation and sustainable exploitation section deals with authorizations, compliance and enforcement, and basically it requires the parties to exchange a list of vessels which they want to apply for authorizations and licenses to fish under the access arrangements in Chapter 3. It requires the parties to issue those licenses and authorizations, and one can see that there could potentially be contention around that issuing process, which is not fleshed out in great detail here. Article 5, Fish 5.2 then requires each party to take all necessary measures to ensure compliance by its vessels with the rules applicable to those vessels in the other party's waters. Now, that's an interesting one because it requires the authorities of each party to properly understand the requirements that the other party has put in place. So again, requiring a high level of mutual understanding. And all necessary measures, I would suggest, is fairly strong wording. But again, the effectiveness of that compliance regime may depend on regulatory and political will and resources. And the exact scope of what it requires in practice is likely to be something which regulatory authorities will need to consider. Now, I've chosen to focus mainly on this presentation on the principles and objectives, because I think they are the provisions that have received much less attention in the press and the public eye. I've just set out briefly here the article titles for the actual details of the arrangements for access to waters. I won't go through them in any great detail, but essentially UK fishing boats will get a greater share of fish from UK waters. 25% of EU boats' fishing rights in UK waters will be transferred to the UK fishing fleet over an adjustment period of 5 years between 2021 and 2026. After that, there'll be negotiations to discuss how the catch should be shared out. The UK will have the right to completely exclude EU boats after 2026, but the EU could respond with taxes on exports of British fish. Given this is such a highly politicised area, it really remains to see how this will be played out. But what I would note is that the UK, of course, continues to be embedded in a system of negotiation based in particular around the concept of total allowable catch. And in many ways, conceptually, there's an element of continuity with the common fisheries policy, and the processes of negotiation which are required are going to be in many ways similar. Finally, Chapter 4 of Heading 5 sets out arrangements on governance. Again, for the purposes of today's presentation, I won't go into any huge detail, but there is provision for an arbitration process following suspension. There's a very broadly worded provision for potential data sharing between the parties, and there is provision for the setting up of a specialised committee on fisheries to act as a forum between the parties. Finally, Article Fish 17 provides for termination with 9 months' notice by either party. I'll leave it there for now, and I think we now have time for some questions. Thank you very much for listening.
Thank you, Tom, and thank you to all our speakers. We do have a little bit of time. We've run a little bit over, but I see from the Q&A function that we've received an interesting question that Ruth has answered. So rather than spend time on that, I'd invite you to have a look at that. That's on renewable energy guarantees of origin. We also have an interesting comment that's been posted there about fish stock management. But I wonder if I could ask Stephen the following question and then turn on to one other. Stephen, does leaving Euratom, we're asked, have any implications for the UK in terms of new nuclear power capacity?
I don't think so, Richard. The UK is one of the few Euratom or former Euratom countries which favours new nuclear build. I think most countries, possibly the exception of Hungary, are now really rowing back on new nuclear build. And it's always been the case that the EU generally and Euratom leaves the choice of energy policy to member states by and large. So we wouldn't have been restricted from new nuclear build under Euratom. We're certainly not without Euratom. I think it makes it easier in one respect, possibly, which is the state aid aspect, because in relation to Hinkley Point C, as people will recall, there was quite a lot of coming and going with the Commission over whether the arrangements, the contract for difference effectively struck between the UK and EDF was contrary to state aid rules. Ultimately, it was ruled it wasn't. But it would mean certainly we wouldn't have to go through that rigmarole again in relation to future forms of support for new build. Otherwise, I think really very little difference. We used to have to inform the Commission of any plans we had for the new disposal of nuclear waste, which would have been something we'd had to go through in relation to new nuclear power stations. That no longer applies, but there have been, through directions made to the Environment Agency by the Secretary of State, equivalent procedures put in place for consulting any Euratom member states which feel they may be impacted by disposal of waste. So no, I think very little difference.
I wonder if I could just chip in my own question to you, Stephen, because you mentioned disposal, and I know that as well as being the author of the leading textbook on nuclear law, you sit on the on Quorum, the Committee on Radioactive Waste Management. I wonder if the work of that committee and including your work is in any way altered by the trade agreement and Brexit more generally.
Again, I don't. We did look at it very closely in the committee and had quite a bit of discussion with BEIS over what they were doing on this. We were generally satisfied that suitable arrangements were going to be put in place, particularly on safeguards, because a lot of this fissile material, when it's in store, places like Sellafield, is subject to safeguards, even though it's waste, or it may be material which hasn't yet been declared as waste. So we were concerned about that, but that seems to have been dealt with satisfactorily. We do have proposals, of course, to try and construct a geological disposal facility to take our higher activity wastes. That won't be changed by departure from Euratom, a number of Euratom countries, such as Finland, Sweden, France, are going down that route themselves. So I think, as with much else in this area, we were concerned initially as to how it would work out, but have been satisfied with the arrangements that have been made.
All right, thank you. I think we've probably got time for one more. A question's come in for you, Tom, and it's this: how far does the UK now have freedom to protect the fisheries in its international waters, i.e. those of up to 200 miles from the coast? And can we extend this to the halfway point between the UK and other nations? So quite a specific point there. Are you able to offer an answer to that question?
Thank you very much, Richard. Well, the UK's fishing waters are now, it's EEZ, it's exclusive economic zone, so that extends up to 200 nautical miles. It doesn't extend further than that. And as I hope I brought out a little bit in my presentation, despite the fact that the UK government frames this agreement as giving the UK freedom to set its rules and regulations, in fact, the truth, I think, is a little more complex than that. And in reality, in my view, it does remain a framework for joint management of resources. Now, that framework, I would suggest, is not a conceptual game changer. There are many continuities with the common fisheries policy, in particular, the framing of fish stocks management as to a large degree an economic issue, an issue concerned with production. That said, there is, of course, the freedom for the UK to implement measures in pursuit of the objectives and with regard to the principles. That's been left open-ended, so it is possible there's room for more manoeuvre there. But then again, one has to take into account the fact that there are the level playing field provisions, which again will restrict the UK's ability to do that. So my overall point is that in reality the UK remains embedded in a framework which is complex and which imposes various restraints on it, and which I don't think marks a major conceptual change from the CFP in the way that fisheries stocks are going to be managed.
All right, well, thank you, Tom, and thank you to all our speakers. Thank you also to all our delegates and to Beth and Charlie, who performed great wizardry in the marketing department in converting barristers who are, like this one, a little antediluvian into speakers on Zoom. Thank you for that. This brings to an end our episodes on the trade and cooperation agreement. It's as I mentioned at the beginning, it's the third in that particular sub-series, and you'll be able to find the content of this one and those on our website should the need arise. But it only remains for me to repeat thanks and wish you all a good afternoon. Thank you.